At the Supreme Court of Canada, the Law Societies of British Columbia and Ontario claim that if they were to approve Trinity's law school, then that would mean they endorse Trinity's religious beliefs and practices on marriage. That, they say, would amount to them discriminating against the LGBT community. It is dangerous to say that the state's approval of a religious entity to operate means the state approves the entity's beliefs and practices. That linkage is dangerous because its net effect is to deny religious communities the protection of the law. The government has a role to protect the public interest by ensuring there is diversity of opinion and practice on fundamental life issues such as marriage. Freedom to think, believe, and act on those beliefs is the cornerstone of our democracy and Constitution. The state has no business forcing its views on religious communities. In 2004, Christian communities requested the Supreme Court to provide protection in light of the redefinition of marriage. They were rightly concerned that they would be forced to perform marriages that conflicted with their religious beliefs. The court agreed that protection ought to be given. The legislature intentionally included protections in the Civil Marriage Act and also amended the Income Tax Act to protect religious charities from deregistration for their position on marriage. The Law Society's argument undermines these protections. In a legal sleight of hand, they say that it is irrelevant that Trinity is a private religious body and not subject to the Charter. They treat Trinity as if it were government and therefore cannot follow its religious teachings on marriage. Here's how they say that. First, the law societies are state actors and therefore cannot discriminate. Second, since approving Trinity's law school would be approving Trinity's beliefs, it cannot approve. In other words, Trinity, by requesting accreditation, suddenly becomes like the state. This argument is simply unacceptable, in my opinion. It has no foundation in law. It is revolutionary to how the law has treated religious charities up to this point. And this is serious. We discuss the implications of this argument next time. Stay tuned.